Hello entrepreneurs, it's Michael Mort with Argent Place Law, where we're the legal business counselors to entrepreneurs just like you. I want to talk to you about independent contractors. Sometimes it's a good idea to outsource some portions of some project that's not in your core competency. You want to get experts involved, for example, to create your website if that's not part of your core competency. Design your logo, perhaps create marketing materials, or even ghostwrite blog entries for you. Now, all of that's creative work that falls the ownership of that creative work falls under the laws of copyright. And guess what? There's a gotcha. Who owns the copyright when you outsource the development of that work? You're paying for it. Who owns it? Well, the default rule is if those aren't your employees, if they're independent contractors, they own the work. The authors, the creators own the work. The independent contractors own the copyright to your website, to your logo, to your blog entries, to your marketing materials. There is a way around this, of course. The law doesn't say that's the only thing that can happen. It's just a default rule. You can have a contract that specifies, that says that at the end of the contract, after you've paid for it, for example, the development, the ownership of the copyright will transfer to you. Now that clause is called, that would be in the contract, in your contract with your independent contractor, that clause is called a work made for hire clause. It's not always found. The independent contractor might not even know he's supposed to do that in order to transfer the rights to you. Or they may know, but they don't want to put it in there unless you ask for it. Sometimes they don't want to put it in there unless you pay extra. But in any case, you need to know whether or not you're going to own the copyright. And I highly recommend you own the copyright to your trademark. But even things like, can you imagine if you had some blog entries written for your website and you decided that you wanted to post them on your Facebook page, and the independent contractor says, oh no, I only wrote that for the use on your website. If you're going to post it elsewhere that's illegally copying and distributing without my permission, I want extra money. You don't want that to happen to you. So make sure that that clause, that work made for hire clause, is in your independent contractor agreement. See, I'm looking out for you. That's why you're watching. I'm Michael Mort with Argent Place Law, where we're legal business counselors to entrepreneurs just like you.